Good morning, everyone. Welcome to Commercial Team's seminar this morning. We hope you're all well. I'm feeling a little bit like I've changed profession and become an airline pilot with these headset speakers on. I hope that we have a smooth ride today. Visibility where I am is not looking great, but hopefully the slides are clear to you all and you can hear us well. In terms of the setup, what I'll be doing is I'll be speaking to some slides, which we will provide you a copy of after the seminar, and we will also provide you with some notes. So if you're someone who likes to sit back and listen rather than take vigorous notes, feel free to relax to do so. There's no need for you to take down a note of every single point as we go along. There is a chat function available in relation to this webinar, whereby you can provide questions as we go along if you have any thoughts. We probably won't pick up on them all as we go along, but we'll have a session at the end when we can come back to those points so we can consider any of the points which have arisen. If there's anything else, Jay, feel free to shout now. Jay Jagasia is speaking with me today. And before we go on to the substance of the notes and the slides, the general disclaimer applies, of course, in relation to anything we say today. In other words, if you set off on a flight on your own in reliance on anything we say, you're at your own risk. So, Coronis and business interruption insurance. We thought we would cover this topic for two reasons. Firstly, because we're seeing an increasing number of inquiries in chambers in relation to this issue, and it's clearly a topic of considerable interest to businesses across the country. I'm just trying to mute the person who's just joined. There are a couple of people who just joined who unfortunately not muted themselves. I've just muted them. Hopefully that has reduced the background noise again now sufficiently, so I'll proceed. So as I was saying, there were two particular reasons why we thought this would be a good topic to cover. Firstly, in relation to number of inquiries, clearly there's a huge interest in the area. Secondly, the literature which you can see online is generally quite pessimistic about the prospects of coverage being available in relation to business interruption losses caused by coronavirus. However, quite a lot of that thinking online is quite superficial and is specific to specific clauses. So I think the message that we would want you to take away from today's webinar is that there may well be a fruitful investigation for you to make with your clients in relation to whether or not there is a potential to make a claim, both in proceedings potentially in court and also in considering pursuing other lines of inquiry and redress under other compensation schemes. So the agenda for today's talk is sixfold. First, we just briefly introduce the backdrop to the talk. Secondly, I'm going to hand over to Jay, who's going to talk about some general principles of construction and also introduce those in the context of insurance policies, because of course the key issue in relation to coverage for business interruption cover requires construction or interpretation of the contract. Thirdly, we will look at the concept of the meaning of the word damage in insurance policies and some of the competing views there are in relation to that concept, and in particular look at some useful recent authority from the Commonwealth as regards that issue, which may shed some light on how the arguments may be developed in this jurisdiction. Fourthly, we look at the question of notifiable disease and the trigger dates and points in that respect so far as coronavirus is concerned. Fifthly, we look at some other typical types of cover extensions which may be relevant for consideration of the issue. And finally, we just briefly mentioned that we're not covering other issues such as causation of and loss, but of course, causation and loss are going to be potentially relevant in any event once you've addressed the question of whether or not the policy it potentially responds. So, firstly, the backdrop to this talk. You will all, I'm sure, have noticed in the press that the FCA wrote a letter to the insurance companies, which has been well publicised recently, and it was sent on the 15th of April, and it referred, amongst other things, to its conversations with the industry, which indicated to it that most policies have basic cover and do not cover pandemics, and therefore there'll be no obligation to pay out in relation to the COVID-19 pandemic. And in those circumstances, they see no reason or reasonable grounds to intervene. They then went on to say, however, that in relation to the situation where there is a clear obligation to pay, then they would be expecting insurers to promptly pay out in relation to such claims. Those of you who have been involved in disputes involving interpretation of contracts, whether or not that is in the insurance context or not, will know that in actual fact, there's no clear bright line between those cases where there's a clear obligation to pay out and those which aren't. There are a variety of potential views that there may be in relation to those contracts. And it's worth noting that the FCA's views seems to have been heavily influenced by the insurance industry's response to their inquiries, rather than a wider perspective from, for example, business owners or others in the marketplace. The FCA's view was obviously sent out to the CEOs, and the industry body response back from the ABI, the Association of British Insurers, is set out on the top of this slide, whereby they seek to respond gratefully to the notion that there's unlikely to be cover in lots of instances, and they then refer to the amount that they expect is going to be required to be paid out in relation to business interruption claims, and they then talk about other ventures that are required in relation to public-private partnerships. We would pause to note that from a lawyer's perspective, a large part of that discussion is not going to be relevant to the process of interpretation of the contract. So how much the insurer may have to pay out is neither here nor there in relation to that. And it seems to us that there's been a lot of discussion about how business interruption cover is never intended to cover global pandemics, and it's limited to well-known perils, and cover requires state intervention. To our reading of the situation, that is an overstatement. There are insurance policies which are intended to cover and provide cover in a variety of different guises and levels for diseases and business interruption. And it's a question of considering the policy in each case in context in order to understand what it is intended to cover. So, in summary, we would urge against a conclusion that there's a that there's a clear-cut extreme between a policy which provides cover and that which doesn't. There are, of course, a number of grey areas between those two, and there's a spectrum of claims which can potentially be brought. There is a middle ground which is to be explored, and there's a much more nuanced picture as regards what may be recoverable. And in particular, as we'll go on to talk about in a few moments' time, there's some persuasive support from some Commonwealth authorities as regards the circumstances in which cover might be available. So over to my co-pilot or co-speaker, Jagasia to talk about some of the general principles before we turn back to look at some of the issues more specifically to coronavirus business interruption claims.
Thanks, Hugh, and bring in the junior to discuss basic principles that I'm sure just about everyone on this call has a pretty good understanding of. But that's what junior barristers are for. So I'm going to run through this pretty quickly because this is subject matter which no doubt almost everyone on this call has a pretty good grasp of. So some basics, just to say that we've covered this off. An insurance contract is like any other contract, and the minute you're into the world of construing a contract, it all depends on the individual terms of the policy in this case that needs to be interpreted. Some more basics. We have seen a number of policies as a result of the situation, and from our experience at least, and I'm sure this will be echoed by most people who've been involved in this area, there are a number of different policies out there, a number of different terms. So each policy needs to be interpreted, even amongst insurers. From what we've seen different policy terms. So a generic approach will only get someone so far in this area because the devil is in the detail. Quite importantly, and this is really kind of one of the take-home messages that we hope that this talk will inspire is that there's no direct authority that's considered these terms, and as I've said, there's a myriad of terms, but there's no direct authority that's considered any of these terms in the context of a pandemic such as coronavirus. Hugh's going to be talking about a Hong Kong case later on, but again, that focuses on quite a specific issue arising out of SARS in 2003, and that is not a case that is authority for an interpretation per se of whether there will be cover or not. And Hugh will come to talk about that case, but wherever there is an authority, the gift of the common law, so to speak, is that it's up for the lawyers to develop these arguments, and no doubt this will be very fertile battleground going forward. So just finally on this slide, it's really a matter of first principles, and people need to approach this from first principles because there isn't much else to go on at this stage. So some general principles. These principles, I should say, and as is well known, are applicable to all contracts. I'm not going to restate the text that's on this slide. It's a well-known passage from the judgment of Lord Neuberger in Arnold and Brittain. So Arnold and Brittain, as most people will know, is the leading authority, together with a few other authorities, on the appropriate approach to contractual interpretation. What I would focus on is in terms of the 5 factors that are set out, that it's the natural and ordinary meaning of the clause that comes first, and that was obviously done on purpose for reasons which I'll come to. And it's commercial common sense that comes in at 5. And obviously, at 6, as has been the case for a long period of time, the subjective evidence of the parties' intentions is completely irrelevant to the assessment. So when one thinks of the ABI statements and some of the other statements that have come out into the public domain from insurers as to the potential nuclear effect of having to pay out under these policies, that's all strictly speaking irrelevant to the assessment. The starting point is the natural and ordinary meaning of words, and commercial common sense does come into the equation, but it comes in towards the end of the equation, so to speak. In that judgment in Arnold and Brittain, Lord Neuberger set out just underneath that passage 7 factors. Only 5 of those factors are really relevant to the current inquiry. I've set those factors out. The headline point, which should be clear from the factors that I've set out, is that it might not necessarily, those factors might not necessarily be helpful to the insurers. Because as I've said, commercial common sense and surrounding circumstances are relevant, but it's not the starting point of the assessment. The starting point of the assessment is the actual words that have been used, and where the words themselves are clear, you can't go to commercial common sense and surrounding circumstances as your first port of call. That's towards the end of the assessment. So the second factor is really quite an obvious statement, which flows from that, which is the clearer the actual words that have been used, the more difficult it is for a court to justify departing from those words. And the same thing applies from the other direction. Where the actual words that are used are ambiguous, that will more readily justify a departure. But it's not the role of the court to go out and to search out ambiguity just to come to the result that it thinks is the fair result. Where the words themselves are clear, then the court has to give effect to those clear words. The third factor is quite an important factor in the context of the current assessment. Because you can't go to commercial common sense retrospectively. So a court can't approach this from the standpoint of, well, this will require the insurers to make huge payments. They were only paid a certain amount of top-up premiums for BI cover. It would be catastrophic to the insurance industry. All of that is, strictly speaking, irrelevant to the assessment. So although non-retrospective, commercial common sense might be an important factor. As I've said, it's not the first port of call, and courts should show some restraint in this area. That's what Lord Neuberger was saying in Arnold and Britton, because there had been a tendency leading up to Arnold and Britton and in cases which have followed where courts have used commercial common sense almost as a starting point. And effectively, what he was saying is that's not the correct approach to contractual interpretation. And the fifth factor, which is quite important as well in the current context, is you can't rely on facts that are only known to one party to be used in the context of contractual interpretation. Only facts known to both parties will be relevant, because fundamentally the object of contractual interpretation is to approach it on an objective basis and to ascertain what, objectively speaking, the parties had intended. In the context of insurance, there's certain other principles which are particularly relevant to the current assessment. So one of them is the fact that in an insurance context, that the parties themselves to the insurance contract are taken to understand the nature and the limits of the business to be insured. The second bullet deals with and the third to some extent as well, deals with what any contract lawyer knows, and it's an approach which is based on a contra proferendum approach to insurance contracts, which is very rarely in an insurance context has the insured had much, if any, involvement in the actual terms. Normally the terms are put forward by the insurer on a take it or leave it type of basis. So any ambiguity in a contract, to the extent that there is ambiguity, will be resolved generally against the insurer. And the third bullet deals with the almost obvious point that an insurer can't put in specific words into an insurance policy which are ambiguous, ask the court to give effect to that ambiguity in circumstances where those terms are quite important, and it can't rely on its own poor drafting. So it's linked to the second bullet, really, in the contra proferendum approach to insurance contracts, which is it's not appropriate for an insurer to riddle a policy with ambiguity and then expect to benefit from that ambiguity. And the fourth bullet deals with a point that pops up with conditions precedent, exclusions, and insurance contracts. But where a specific term is particularly onerous, and those terms generally are held to be onerous or draconian, it's incumbent on the insurer to clearly spell out the effect of those clauses. I've mentioned, and as Hugh mentioned, we've got a 17-page note, which we've worked on over the last few days, which will be made available to you after the talk. But there are a number of cases that are cited in there, clear citations and page reference numbers. But one of the recent cases in an insurance context, and it popped up in a case which was considering primarily conditions precedent, is Wielden Brothers and Millennium, which is a relatively recent decision which considered not only general principles of construction, but specific principles of construction in an insurance context. And we've mentioned that on that slide, and in the notes, you'll be able to track through the citation to be able to find that case to the extent that you're interested in reading more. Over to you, Hugh, I think.
Great. Thanks very much, Jay. We are now going to move on to consider one of the key issues which crops up in many of the construction or interpretation problems associated with business interruption insurance claims, and that involves the question of the meaning of the word damage, physical damage, or loss and damage, accidental loss and damage, etc., which can be found in the policy, because of course the trigger point for many business interruption claims will be based on the notion that there has been some accidental loss or damage to the premises or business in question. And many of them do not necessarily contain a clear indication in them as to precisely what the meaning is to be attributed to the word damage in the policies themselves. And some of them will contain definitions which are ambiguous or circular. And so that gives rise to a common question in all these claims as to how the courts are likely to interpret the word damage in the insurance policy in order to ascertain whether or not a relevant incident or event has occurred which triggers a responsive policy. It's worth starting out by looking at the ordinary meaning of the word damage in English language. And if you look it up in the dictionary, you'll find a number of different definitions. Commonly, however, and just taking, for example, the concise Oxford Dictionary definition, it provides that damage is harm or injury impairing the value or usefulness of something, or the health or normal function of a person. So obviously it's the first part of that definition which is the primary focus for us. That leaves the matter quite open. Harm or injury impairing the value or usefulness of something. The more specific question which is likely to arise in the context of coronavirus is whether or not damage requires some tangible or physical change to the premises or to a particular location or business enterprise, such that the policy may be said to respond, or whether or not simply temporary loss of use can be said to constitute damage. And of course, the general discussion we're having here is heavily influenced by the specific context which may arise in the particular policy you're looking at. So, for example, if you're looking at an all-risk policy, the approach the court may well take to interpretation of the policy may differ from a policy which doesn't provide an all-risks approach. Starting off with some of the English and Wales case law in relation to the meaning of damage, some commentators have suggested that the traditional English approach is a narrow approach and requires some sort of physical change. And reference to that view is taken largely from a Court of Appeal decision called Pilkington United Kingdom Limited, and CGE Insurance Limited. This case concerned the limits of cover where a product, some glass panels, which were heat-toughened glass panels manufactured by the well-known manufacturer Pilkington Glass, for installation in the Eurostar terminal at Waterloo Station. And the question which arose in the context of an earlier dispute involving the contractor, who ultimately sought to recover monies from Pilkington and Part 20 them in earlier proceedings, in relation to the question of the recovery of management and remedial works costs associated with the removal and reinstatement of the particular panels which were themselves defective. There were a limited number of panels which were defective. Those defects did not cause physical damage to the surrounding structure within the terminal. And having paid out by way of settlement on the third-party claim, Pilkington looked to its insurers to recover its losses arising in relation to the claim it had to pay out. The critical issue for the purposes of the decision was whether or not the claim was one in respect of loss of or physical damage to physical property not belonging to the insured. That was what the cover provided. There was also a specific exclusion within the policy for defects within the product supplied itself. And I'm sure all of you on this webinar will immediately be thinking that provides some difficulties for the claimant in the context of this case, and that's indeed what transpired. They lost at first instance on their arguments and lost also in the Court of Appeal. However, what's of particular relevance to today is to consider some of the observations made by the Court of Appeal in relation to, in particular, the meaning of the word damage in English law. And in particular, Lord Justice Potter, giving the leading judgment, stated that in English law, damage usually refers to a changed physical state. And in this respect, reference was made back to an earlier decision, the Nukila, which we'll come back to in a few moments' time. He went on to say, however, the precise borderlines of the definition depend on the context of the word or words used. And he went on to say, for example, for the purposes of indemnity, it will normally be necessary to demonstrate the physical changes occurred. However, that is not this case. So he referred, apologies, I skipped over something there. He said, thus, while for the purposes of indemnity, it will normally be necessary to demonstrate the physical change occurred, that is going, sorry, someone just skipped, another user took control of the slide. I'm just skipping back to the relevant page. So for the purposes of indemnity, it will normally be necessary to demonstrate the physical changes occurred in certain circumstances, in certain contexts, with clauses, for example, which refer to loss or damage, then there's a potential for recovery of economic loss, even in the absence of physical damage. So we'll come back to that in a few moments' time. But the short takeaway point is that in the context of this policy, they concluded that the relevant words required physical damage, and further that it must be to the physical property of another. So in those circumstances, the policy was not responsive. So generally speaking, it might be said damage requires some altered state, the relevant alteration being harmful in a commercial context, but the context and wording of the policy will be key. The three key points that we need to identify in relation to Pilkington as to why you need to be cautious about placing over-reliance on it in the context of all policies.
Hugh, sorry to interrupt, but on my screen, and I'm sure it's probably the same for everyone else, we've gone back a slide.
Okay. Let me just take control back. I'm not sure why the slides were lost there. Can you still see them?
The slides aren't up, so I think you need to upload them.
Apologies, not quite sure what happened there. Some turbulence on the flight. Hopefully, normal business will be restored shortly.
Yeah, so they've come up. You just need to skip the slides to get to the right slide.
Okay. Well, I've still got the circle of doom on my computer whilst it's loading up. So if I just give that a few moments, you could maybe take control of the slides, Jay, while it's loading on my computer, and you could maybe take us to the relevant page.
That function hasn't popped up. Apologies, everyone. This will just take a minute or so.
We've seem to have an IT issue with problems displaying content. I'll try and upload it again now. We'll just give it another couple of minutes to see if it works, because it's much easier, I think, for people to follow if we've got the slides up. But if for whatever reason it doesn't upload for technical reasons, what I propose to do is just to carry on in a few moments, but without reference to the slides, and we'll provide the slides after the seminar. But we'll just give it another minute to see whether or not that's coming back up. I'm not quite sure why it's been lost. Is it still not come up on your screen, Jay?
No, it has, but I don't have the function to be able to take control. The slides hasn't popped up.
Okay.
But it's the first slide.
Okay. Is it still on there?
No.
It is gone again now, has it?
Yeah.
I'll try one more time, and third time lucky, and then if this doesn't work, then we will abandon the slides and we will just circulate them after. So one more time. It looks like third time lucky. Are they back on your screen now?
Yeah. Good stuff. Yeah.
good. Something funny was going on at one stage before then. The slides jumped back, so I don't know whether that was someone who unfortunately clicked on them, or whether or not it was just a glitch in the software. But in any event, I think we were skipping through Pilkington, and we got to this slide when we were talking about the 3 points, just to remind ourselves in relation to the Pilkington decision. The first was that the policy wording at issue was a double whammy of contained the words physical damage and also to physical property of a third party, which one might think is a fairly clear indicator as to what the outcome of the decision should be in that case. You won't always get the use of the word physical. Secondly, the policy was not intended to provide cover for protection arising from and contained exclusively within the goods it had itself supplied, and so in those circumstances it's probably unsurprising. And the exclusion concerned defects in goods, which itself was also an indicator that there needed to be some poisoning or contaminating effect on third-party property, which simply didn't exist on the facts in this case. So we draw attention to all those 3 points to illustrate why the interpretation approach of the courts is heavily fact sensitive. As I mentioned a few moments ago, Pilkington referred back to the case of the Nucilla, which is an earlier decision. Again, we refer to this in the notes, so feel free to look at those in further detail in due course. But this was referred to as authority for the proposition that damage usually requires some change to the physical state. The important point to understand in relation to the Nucilla decision was that this case focused on the question of hull damage, and in particular the debate centred on latent damage to the hull. The particular operation in question involved a floating platform in the Java Sea, and the particular defect which arose in relation to some welding on a joint between the legs of the floating platform and what were referred to as spud cans, which were welded to the bottom of the legs, and those spud cans were in effect the feet of the platform, and there were some very minor fractures within those welds, which then became more substantial and spread very substantially, causing damage, it was alleged, to the vessel itself. And the particular passage in the case which is referred to, which we've got on this slide, is if a latent defect has existed at the commencement of the period, and all that has happened is that the assured has discovered the existence of that latent defect, then there's been no loss under the policy. The vessel is in the same condition as it was at the commencement of the period. Therefore, the assured has to prove some change in the physical state of the vessel. If he cannot do so, he cannot show any loss under a policy on hull. If, however, damage has occurred, that does involve a physical change in the condition of the vessel, and that can be the subject of a claim under the policy. So you might think that, bearing in mind the issue which arose, which was to do with the extent to which a latent defect had spread to cause defects in relation to other parts of the vessel, the interpretation to the concept of damage in that context was clearly going to be focused on the question of physical damage. As it happened, the Court of Appeal took a different view from the first instance judge as to whether or not the welds themselves could be said to form part of the structure, so as to be able to provide recovery for a claim or not. But the important point to understand in relation to all of those decisions is that physical damage itself does not extend to damage contained exclusively within the goods, nor does it extend to latent hull damage which existed prior to the inception of a hull and machinery policy, which required some change in the physical state of the vessel after it was incepted. Those are unremarkable propositions, and one has to bear in mind that the general observations made in the policies were set in that context. So we ask ourselves, bearing that in mind, is there a case which provides a context which may be closer to the context which will arise in the context of the coronavirus claim outside domestic law, which might provide us with some more information? There are also some domestic cases which Jay, I think, is going to briefly look at, but I suggest, Jay, bearing in mind the hiatus in relation to the slides for a few minutes, that you give this a very light touch.
Yeah, and Hugh, I don't know if you've seen the chat function, but it would appear from the comments that have come through that I can see the slides and quite a few people can see the slides, but it sounds like some people can't see the slides. So
okay.
In those circumstances, I would suggest that we continue on. Apologies to the people who can't see the slides. I'll do my best, and Hugh will no doubt do his best to try and make the talk understandable to the people on slides. But as we've said, the slides will be made available. There's full notes, so you won't be disadvantaged, so to speak, except for the fact that you'll just have to listen to Hugh and I. So I'll do my best, and apologies to the people who have difficulties. So moving on quite quickly through Galandris. Galandris was referred to in Pilkington as support for the broader view. The difficulty with Galandris is that Galandris is an extremely specific case that was set within the context of a claim for loss or damage to goods that were in transit. The Hague rules applied. And those specific Hague rules had already been interpreted. So one was interpreting an insurance policy against a context and a backdrop of very specific provisions which had also been interpreted. So Galandris, the decision itself, extended the meaning of damage to intangible loss, which on the face of it sounds very good for the broader view, and especially in the current context of the pandemic. On the face of it, it might sound like it's quite a helpful decision, because in Galandris, if loss can extend to intangible loss, then why shouldn't it extend as well to a situation where a premises can't be used and there is no physical damage? The difficulty is it's a very specific case, and Hugh has already alluded to the fact that Pilkington on the face of it might look damaging, the Nikila on the face of it might look damaging, but actually when you take a more nuanced approach and you actually read the decision, they're both quite unremarkable decisions when you set them within their context. Well, all of that applies to Galandris as well. On the face of it, it might be considered to be helpful, but actually when you drill into the detail, it's most unremarkable, and on its own, it's unlikely to be very helpful to a broader view in the context of coronavirus. Much closer, and this is our final case on damage, but it's a very, very recent decision. As a proud flag-bearing Canadian, it makes me extremely proud to see a Canadian decision, which I should say is extremely well reasoned, as you'd expect, and supports perhaps the little guy and has adopted a broad approach. For reasons which I'll come to, we consider it to be extremely relevant because unlike the cases that we've considered in a domestic context, we consider this case to be much closer, much more apt to the current situation. So it's an extremely recent decision. It doesn't concern the pandemic, but it did directly head on consider the meaning to be attributed to damage. The actual term itself in the policy was physical damage. And it still adopted a broad approach. So one would suggest that where a policy is bounded by damage and not physical damage, that it's an a fortiori situation. Of course, it's a persuasive authority only, but as a proud Canadian, I would suggest it's a highly persuasive authority. But on a more important point, it directly considered the two camps. It's much closer to or comparable to the current situation. So just quickly through the facts, the claimant brought a claim against its insurer for lost profits. The actual loss was caused by the shutdown of a nuclear facility. The facility is based just outside of Ottawa. It's one of its kind in Canada. And it wasn't premises that was actually owned by the insured. It's where the insured got its radioactive isotopes and processed them from its facility and then sold them worldwide. These isotopes are used for all sorts of medical purposes. It should be relatively obvious, but as a result of the shutdown of that facility, because there's been a leak, it's a nuclear facility, and there was a threat of harm. So no real damage per se, a leak of heavy water, a quite prudent shutdown because it's a nuclear facility. But the insured in this case couldn't get its isotopes, and it's not the type of goods or material that you can find a ready replacement for, certainly not in Canada. So the final two bullets set out the battle line, so to speak. The defendant insurer argued, well, it's the presence of a threat. There's no actual physical damage. It's just really loss of use. And that what was actually required was actual tangible damage to property. Whereas the insured, the claimant, argued to the contrary and said, well, the leak itself, which was capable of shutting down the facility, impaired the use or the function of the premises as a whole. So when we look at that final bullet, you can quite readily see the arguments and just how comparable that might be to the current situation, where an insured under a BI policy will be arguing, well, there might not have been physical damage to my property, but as a result of the virus itself, and if you take a broader view of damage, we couldn't use our property or our premises, and as a result, we couldn't trade from our premises. So as I've said, just quickly, the central issue in this case, at least the one that's important to us, it's a 130-page judgment. The central issue that's important to us is whether a broader or narrow approach should be adopted. And I've already mentioned the point that this was a case where the actual relevant policy terms extended to or were bounded by physical damage. So the judge had considered, and no doubt the legal representatives of the parties had put quite a lot of material before the judge as to the interpretation of damage. There had been a few Canadian cases which had considered it. There had been a few American decisions that had considered it, and there had been a few Commonwealth decisions that had considered it. And all of that material was put before the judge, including Pilkington. So Pilkington was considered as part of the judgment. And despite Pilkington, the judge really kind of felt, well, the question's an open question. There's two approaches out there. There's the narrow approach and there's the broad approach. And context is everything when you actually start drilling into the detail of these cases, which is a point that we've really tried to emphasize. Because the judge really, at the end of the day, after hearing argument on the topic, felt like there wasn't that much out there which assisted her and which tied her hands as to the approach to be taken, because each policy needs to be approached within its own contextual framework. Importantly, we would say, after hearing full argument on the point and on hearing about all of these cases, the court rejected the defendant's insurer's argument and considered that the meaning of physical damage was appropriate, or a broad approach to physical damage, which could extend to impairment of function, loss of use, and didn't require actual tangible physical damage to the property itself, was appropriate in the factual context of the case when squared against the actual policy terms and specifically resulting physical damage. So it really is a case that the take-home message that we'd like to fit and hopefully comes across is that it's a case which is much closer to the current situation than any of the cases in domestic law, It was a straightforward fight between the narrow camp and the broad camp. The broad camp won, and the judge, to a large extent, was influenced by the fact that it was an all-risk insurance policy, and that influenced her interpretation to a large extent. So from a lot of the policies we've seen, they are all-risk policies. The BI policy bit is an extension to an existing all-risk policy. But the take-home message, hopefully, is that we've got a decision from Canada which is potentially quite useful to support an argument that damage, and even physical damage, where those terms are used in underlying BI policies, that the court should approach it on a broader basis than strictly requiring actual damage to the property itself. Because there's little in this jurisdiction to tie the hands of the courts, and we hope that's clear from our analysis. It's a powerful basis to argue for the broader approach. It's some much needed optimism where, as Hugh said, the discourse, at least from what's publicly available, is one of pessimism. It should be noted that we haven't been able to find anything from the AEI which has made any mention of this case. It's also potentially relevant to not only BI cover, but Hugh's going to talk about other aspects of cover which might be potentially relevant. And those aspects of cover will almost invariably use terms like damage or physical damage or permutations. So it's not just relevant to BI cover. If we could persuade a court in this country to adopt this approach, then the arguments are even more powerful where it comes to just damage and not physical damage. And just finally on this point, it's an example of the large gray area. It's a false dichotomy to just talk about policies which won't respond full stop and policies which will respond and are absolutes. There's a huge continuum of gray in between, and it's really an example of that as well. So I'm going to pass on to Hugh to finish the talk.
Thank you very much, Jay. And yeah, certainly a very well-reasoned decision of Mrs. Justice Wilson in Canada. And I think, as I understand it, Jay, there's likely probably to be an appeal in relation to that decision. So it's worth watching that space in relation to that as well. But certainly it gives food for thought as to how the particular question may be addressed by the UK courts. And provides a further very useful contribution, an up-to-date contribution as to the debate as regards the use of meaning of the word damage within BI policies. I just wanted to move on briefly now to talk about a decision of the Hong Kong Final Court of Appeal called New World Harbour View and Ace Insurance. This was another business interruption case which considered the impact of severe acute respiratory syndrome, or SARS, arising from the outbreak in 2003. It involved the interpretation of two composite mercantile policies, and the insurers lost on the points in the lower courts and also in the Final Court of Appeal. I'll skip through it quite quickly because we are fairly short of time, but the relevant clause that was in issue for the purposes of consideration in this case is a clause which you see cropping up with some variations and to some degrees in some of the policies which you now see. So clause 14.5 states as follows: this policy is extended to ensure actual loss sustained by the insured resulting from a reduction in revenue, an increase in cost of working as a result of murder, suicide, infectious or contagious disease, food or drink poisoning or contamination, and closure by a competent authority due to vermin or pests, all occurring on the premises of the insured, or of notifiable human infectious or contagious disease occurring within 25 miles of the premises. So there were two potential causes contemplated by the clause. The cause which was in issue was very much the last part of that clause. So in other words, the concept of notifiable human infectious or contagious disease. And in particular, there was argument as to when SARS became notifiable and what notifiable meant. some policies contain that wording, and so it may be of relevance for you to consider that in the context of this case. The conclusion was that notifiable imports a legal or mandatory requirement to notify. So assuming that this reasoning is followed in the English courts, where the trigger is whether or not the disease is notifiable, this is likely to be construed as at the date when it became compulsory for the medics to notify public health immediately as a matter of law. There's also some discussion in that case as to when loss might be measured from. That's not for the purposes of today's talk. Just dealing with the taxonomy, I'm sure this is all familiar to you, but just briefly so you understand, the virus has obviously been identified and named, and COVID-19 is the name given to the disease caused by the virus SARS-CoV-2. We then have a timeline in terms of public health regulations, which identify certain dates for you when the disease became notifiable in England and Wales. And of course, then the all too familiar story in terms of the steps taken to restrict activities across the UK. And in particular, we've given you reference to the relevant regulations which applied in that respect. So that gives you some potentially relevant dates to consider in the context of policies whereby they're linked to whether the disease has become notifiable, and moreover the steps taken by the public authorities to close or restrict activities in business premises. Other triggers and extensions you may want to be aware of and have regard to are contamination cover extension clauses. You need to have regard to those both in the context of whether or not there is cover provided for those, but also to the extent to which there may be exclusions relating to that. Secondly, common extensions which are included in policies are denial of access cover, which they themselves may provide a basis for a cover above and beyond the basic cover which is provided. Whether or not linked with those other triggers, there are clauses and policies which contain references to acts of public bodies which result in denial or restriction of access, and that may also be a route to cover. And there may also be disease extensions or provisions. Typical issues which arise in that context will be the extent to which there's a list approach or a generic approach, because of course if it's a list approach, then COVID-19 may well not be included on that list. You will all, I'm sure, have seen some publicly reported information about the Hiscox dispute and the threatened group action in relation to wording contained in certain Hiscox business interruption cover. In particular, it's been reported that the wording which is contained in that policy provides as follows: we will ensure for your financial loss resulting from an interruption to your activities caused by public authority, your inability to use the insured premises due to restrictions imposed by a public authority during the period of insurance following an occurrence of any human infectious or human contagion disease, an outbreak of which must be notified to the local authority. So on the face of it, that would appear to be a responsive cover. However, of course, the full context and detail of the clause needs to be identified. You'll have noted that there's been some public outcry at the fact that Hiscox has repudiated cover, but of course the detail of that policy will need to be considered in each case. But it does give you an illustration of certain cover wording which on the face of it ought to appear to provide a route through for insureds. The only other issues we just thought worthy of brief mention is we've been focusing on coverage issues for the purposes of this talk, but there are of course relevant exclusions you may need to consider as well as coverage clauses which interrelate, and there are also questions of causation and losses. Insureds may refer to a case called Orient Express, which I don't have capacity to deal with in this talk, but it's referred to in brief terms in the notes, which is a case which considers whether or not in the aftermath of Hurricane Katrina, a business which had to close due to business damage could claim for business interruption losses or not, in circumstances where, because of the devastation around it, it might be said that actually no custom would in any event have arisen, even if the hotel itself or the premises itself had not been damaged. And a certain view was taken in that case as to the application of a but-for test, which was not positively insured, but it should be noted with some caution that the judge in that case observed that the matter might have been different if it had been argued differently or found differently at first instance. And there are also complicated issues to do with whether or not the causes were interdependent or independent of each other, which don't necessarily apply to the COVID-19 situation. Permission to appeal was reportedly granted in that case, the Court of Appeal, and the case settled thereafter. So don't necessarily be put off if that case is waved in front of your nose in relation to your claim. The picture is more nuanced, again, in that context in relation to the current position in relation to COVID-19. Finally, mitigation steps, of course, need to be borne in mind, and the prudent insured, of course, will have that in mind and have regard to that when considering the circumstances and the amounts that they can recover, and that needs not to be forgotten in the context of advising in relation to any potential claim. So that's very much a whistle-stop tour to try and finish the notes off. I think that at this stage, Jay, unless there's anything further you wanted to add to what I've said, we would probably just have a quick look at the chat function to see if there are any questions arising out of any of that that anyone want to ask, and we will stay online for a few moments for those who want to share questions with us on the chat function. If people don't want to do so, then they can also raise matters with us offline as well. But I think there are one or two that maybe are coming in now for those who can stay online for a few more moments. So let's look at them. There's a question from James Lewis, I think, Jay.
There is, yeah.
So James has asked the question, with policies containing business interruption wording similar to Hiscox's wording, do you have any advice on what public decisions would be the appropriate trigger for a claim under the wording? Well, if we go back to the wording in the Hiscox's wording, restrictions imposed by a public authority during the period of insurance, the likely key restrictions going back to the trigger dates are likely to be involved in the not simply just the notifiable disease notification, but in particular the restrictions brought in on the 20th of March as announced by the PM. And I think actually the legislation came through in a few days later. So that is likely to be the relevant trigger point in relation to those. But of course, it will be context specific, and you'll need to look at the entirety of the policy in order to work out what the trigger point is. If the trigger is just simply whether or not the disease is a notifiable disease or not, then it's likely to be an earlier point in time, assuming that the decision in the Hong Kong case is followed. There's another question, I think.
Yeah, from Mark Aspin.
Mark Aspin, in relation to the Hong Kong case.
Yeah, and I think the point that emerges from that, and Hugh, obviously this is a case that you've reviewed in detail, but is potentially linked to the forensic analysis of being able to prove if there is a territorial limit, like in that case of 20 miles, potentially linked to being able to prove that. So I'll hand over to you to consider that.
I'm afraid because of the conversation, it's just come out of my view, but let me just go back and look at it again.
So the actual question for people that are interested in Hugh, this I can deal with reciting the question, is on that Hong Kong case, the policy wording you highlighted also mentions a 20-mile requirement.
Yeah, okay, yeah.
Did the court consider how that applies as well? For instance, in current circumstances, there's probably COVID-19 cases.
Yeah. Yeah, so the short answer in that case was the parties proceeded on the basis that requirement meant that if there was a SARS outbreak anywhere in Hong Kong, then the requirement was satisfied. So that wasn't really a contentious issue before the final Court of Appeal. It remains to be seen as to whether or not insurers will be trying to take the point that you have to prove that on each case. It seems to us that there's a good argument for saying that the effects of the coronavirus are so widespread and so omnipresent, so to speak, that there's a presumption which would apply factually that it's pretty much everywhere. And so if there's a 20-mile provision, you are likely to be in a scenario where you should be able to prove that. But we're still in early days. Insurers may well be trying to take points at different points in time, depending on when and for how long the claim is sustained. And in due course, parties may need to consider the extent to which they need to build evidential material in support of an argument in that respect in the particular case that they're dealing with. But it seems to us that there's likely to be an evidential presumption in terms of starting point that, bearing in mind the omnipresent status of the virus, that you're likely to cross the sort of the initial evidential threshold. But if the point is taken and you can see that there's a potential argument to be raised, then people need to start to think about how they evidence that and gather material to do so.
And I would just add on a normal separate point that you know, with some of these policies where it requires it at the premises, there's also the additional complicating factor, as Hugh alluded to briefly, of being able to prove the existence of the virus at the actual premises itself. And we all know that the virus itself doesn't remain on surfaces for a very long period of time. So there's a number of potential forensic hurdles that might need to be overcome, even if you can get over the coverage hurdles that we've tried to focus on.
Yeah, I mean, I think in that context, it's also worth bearing in mind that in relation to the issue of presence at the premises, if your conclusion is your policy requires you to prove presence at the premises in order to trigger a claim, then as Jay's identified, that may provide evidential obstacles in relation to the premises. The wider question which arises in relation to loss of use arises not simply because of the presence of the virus at any one particular premises, but because of its presence generally in the community and the effect of the public authority's decision-making process. And that's then likely to open up the wider arguments in that respect.
And I can see that there's a few more questions, and there's one that we'll come back to, but I can see Richard's raised a question which I think we've just tried to cover off to an extent, and that question was, would we need to prove that somebody within a business was diagnosed with the virus before claiming the loss under the policy? And obviously it all depends on the individual policy terms, but where we've seen quite a few policies. And I should say, coming back to what Hugh was talking about in the distinction between, you know, specific lists of diseases and generic wording, I think we all have to accept that coronavirus will not be in a specific list, because when that policy was incepted, no one knew about coronavirus. But where you've got the Hiscox type wording and it's generic, some policies will have a requirement that needs to be based at the premises itself or within the vicinity. And I think what Richard's asking as well, where there's a policy that specifically requires the presence of a virus at a premises, would you need to be able to prove that? And the answer, I think, forensically and subject to seeing side of those terms is that that is likely to be quite fertile battleground in terms of the insurer saying, well, the cover might respond, but you need to go out and prove that the virus actually existed at the premise, which will be a very, very difficult task. And it also cuts through issues of quantum too, because if the premises, or if the virus would have only existed on the surface for a matter of days, then what's the scope of loss that would respond in those circumstances. So I think we've covered that off, Richard. But
yeah, I think the other important point to sort of tease out on that point, which is it depends on the wording of the policy again, all of this, but it probably wouldn't be that common to necessarily require a diagnosis as such. And of course, very few people can obtain a test in relation to coronavirus. So it may well be that should that be a relevant criteria so far as proving the matter is concerned, other evidential material might need to be have regarded to than simply a test, such as whether or not the symptoms are more likely than not to be indicative of coronavirus. But as both Jay and I have said, we suspect that the more fruitful lines of argument will be not simply restricted to whether or not you can prove presence of the virus at any particular site for the reasons we've identified. So if you can do so, then that obviously may well be a helpful measure to take in the particular case you're looking at. Another question was raised, I think, in relation to supply chains by Menzies, in relation to the question of any thoughts in relation to claims sourced in supply chain or key customer disruption post-lockdown. There may well be business interruption claims to be made by those customers independent of the question of whether or not they have property cover or business premises which are necessarily covered in their own right, as may be the case with property damage. So it depends on obviously the particular facts and circumstances of the case, but the incident may be a relevant triggering incident in relation to those customers, and it's certainly worth looking at the policy wording to see whether or not there might be an avenue to explore in that respect. Other questions? There is another one, I think.
Yeah. So Simon Thomas has and it was something that we were hoping to have a bit more time to talk about, but it deals with the interplay of FAWs and the eligibility of many SMEs. And yes, I mean the short answer is yes. FAWs is a potentially relevant if the business itself qualifies and satisfies the tests. Those tests are it's quite easy to find out what those tests are. I'm sure Simon knows those tests anyways. But yes, it is a wider jurisdiction of fair and reasonable. But from our experience, and I've had quite a bit of experience on other types of cases outside of the insurance context, but involving investment, selling, and all of that. So yes, it is a wider jurisdiction because it's grounded by this fair and reasonable. But they, of course, have to have regard to the law as well. So there's an interplay and sometimes a tension between that fair and reasonable approach and the law itself, because obviously the FAWs is potentially within the jurisdiction of a challenge to the High Court by way of judicial review. So it is given a wider range of wriggle room. But from our experience, at least, it does apply legal principles, and it will have to have regard to those legal principles as well. And it might be a fruitful avenue to pursue. It might also just adopt the approach that we've seen coming out from the FCA, and there's a lot of noise out there of most of these policies just simply won't pay out unless they're absolutely clear cut, similar to Hiscox type wording. So perhaps I'm being the pessimist now, but from experience, adjudicators initially at FAWs and then the ombudsman afterwards, if you challenge it, might not approach the issue with the rigor that you would expect from a court, but it is definitely a potential avenue to pursue. And obviously the benefit subject to the limits, which I think is £350,000, is that it's a cost-free jurisdiction, so to speak, in the sense that there won't be an adverse cost award. and if it doesn't bear fruit, then you're not taking on that type of cost risk. Hugh, do you have anything to add to the FOS point?
No, certainly. I think in the notes, which will become available in due course, we referred in brief terms to the possibility of a FOS claim in paragraph 4 of those notes, and refer to the relevant limits in terms of claim. I suppose there are 3 factors to consider in that respect. One is obviously how quickly FOS will be able to deal with these matters. That's an open question right now, depending on how many claims they receive. And secondly, obviously, in relation to them, there's the limits in terms of what can be recovered. But thirdly, yes, if for some SMEs who are eligible, who are wanting to have a conversation with their lawyers, certainly the message is a valid one, that look, even if you're not necessarily in the game for wanting to invest in litigation and investing in court action, it's worth you investing some time with us, because we can process a FOS claim for you as well if you want to, and marshal that to try and get a recovery for you under that route as well. So it's certainly additional potential arrow, so to speak, to be worth considering for clients. So I think it's a valid point, and it remains to be seen whether or not they actually approach a more benevolent approach to insureds than it might be considered that other people such as the FCA have done so far. So I think it's a watch this space, and certainly worth considering pursuing that avenue.
And just finally on that point, my understanding from what I've seen is that although it's still at an early stage, the FOS has indicated potentially that it might start approaching this matter by way of almost group or test cases. So take very similar policy wording and approach it on a test complaint type of basis, and hopefully that should give other people an opportunity to review those test cases and review the policy wording, to find out whether they would fall within or without. So it might not be something that you have to do on the front foot, because someone else might do it for you. So it's definitely a watch this space type of situation.
Yeah, good.
Suki Mills has just raised one further point about the fact that coronavirus has been around in different forms before, and presumably in support of suggesting, well, to the extent that a policy does cover existing viruses or something like that, it might fall within the policy because there are other manifestations of coronavirus. Although my understanding certainly is that it's novel. Hugh, do you have any views on that?
Yeah, it's obviously forms part of a family of viruses that genetically related to SARS, and there are other types of coronavirus there. I suppose that argument might be said to cut 2 ways. If it's said that coronavirus is generally we're in contemplation, it all depends on the wording of the policy and how the disease, if you're talking about disease extension cover, whether or not there are specific lists or categories of virus which are identified, and what words are used in those lists or generic descriptions. But certainly if it's generic wording which refers to an infectious disease, then I agree that there's no reason why the coronavirus COVID-19 disease shouldn't be covered by such wording on the face of it, obviously subject to exclusions and other arguments there might be in any individual case.
I think that's covered off most of the questions. We're easily contactable, so to the extent that there's anyone still on the webinar and they think of a question afterwards, it's quite easy to get in touch with us, and we'll do our best to answer questions that we can. Thank you for your patience, and apologies as well for the IT issues. We hope that didn't affect too many of you, and detailed notes and the slides will follow.
Yeah, if I could echo that, and thanks very much, Jay, for co-piloting this particular seminar. We will hopefully be providing with some further webinar sessions for for people to participate in the forthcoming weeks, including looking at topics arising from COVID-19 in the commercial context. So hopefully you'll receive further updates and email notifications in that respect. But thanks very much for joining us, and stay safe, and we hope you all have a good day for the rest of the day. Thank you.